May I please your lordship. Item number 8, lordship. I am praying for adjournment of this day only. Lordship.
8.
8, lordship. Raviram Das.
Hmm.
It is connected with 9 and 10.
Yes.
9 and 10.
Connected, lordship.
Yes.
Only for lordship today.
You want
again.
adjournment? You could have circulated mention memo yesterday.
Lordship, I have informed my friend also, so other colleagues who are connected.
You have informed him. Have the courtesy to inform the court also.
Sorry, lordship. Next time I will do that.
Yes, Mr. Dhar. Year 2002, 22. Mr.
I heard in letters.
J. Colita.
Here, bonds.
Mr. J. Colita. Learned counsel for amicus.
I am not
Amicus.
amicus, lordship.
Huh?
I am not amicus in this case.
Legal aid counsel.
No, lordship. I have been appointed by the flight.
Okay. Mr. J. Colita. Learned counsel for the appellant in H. Bhagwati is available.
I have informed him, lordship.
And Mr. Adhor, learned amicus curiae for the appellant in 10 are present. First of Ms. B. Bhuya, learned senior counsel and additional public prosecutor for the respondent state is also present. First of Mr. Colita, learned counsel for the appellant has sought an adjournment. And it is submitted by him that consent has been taken from the learned counsel for the respondents, other parties to make the mention, to make the prayer. First of the prayer is not is the case. It is the appeals after 2 weeks on a date to fix.
Lots. Obliged.
May I please, your lordship? Your lordship, I beg to mention I criminal 469/24 in criminal appeal 158/2024. Kindly the matter may be listed tomorrow, your lordship. Urgency is there, your lordship. The matter was listed last listed on 21/5/2024.
What is the matter?
Sir, Section 6 of the POCSO Act, your lordship.
Huh?
Section 6 of the POCSO Act, your
Oh,
lordship.
yes. For what?
For imprisonment, your lordship.
For what?
For orders, your lordship. Listing a matter. for-
Orders.
Yes.
Orders for what?
The matter was listed on 21/5/2024, your lordship.
Hmm.
So I kindly humbly request you to just
Matter is admitted.
matter admitted, your lordship.
Paper book is ready.
I'm not aware of this, your lordship. I'm not keenly aware of this.
Of which year?
24, your lordship. 23, your lordship. 23.
Next week.
May I please, your lordship. My lord, I beg to mention item number 5, my lord. Mr. H. Gupta, amicus for the case, my lord, he is out of station, my lord, presently. Can it be
You are
taken
Mr.
next week? Why board, your lordship?
Y. Borbunia,
Lordship.
learned counsel. On behalf of Mr. H. Gupta, learned amicus curiae for the appellant in appellant has made a prayer for adjournment on the ground that Mr. Gupta is out of station on personal ground for personal reason. First of Ms. P. Bhuya, learned senior counsel and additional public prosecutor for the respondent state, who is present, has no objection to the prayer. Place the appeal after 2 weeks on a date to be fixed by the office.
May I please, your lordship? Lordship, I beg to mention for listing of a urgent matter, that is a appeal against conviction, my lord. And it was listed last 24/6/24. And Honorable this court has ordered to list this appeal. Till now, it has not been listed. my
Matter is admitted. Of
lord.
which
Yes,
year?
my lord.
Of which year?
2024, my lord.
2024.
Yes, my lord.
5th
5th of.
Orders. Orders.
Highly obliged.
Date are delivered.
For hearing item number 1.
Received, lordship.
Yes.
Report received. lordship.
What report?
Regarding lordship, a grant of benefit of remission to the convict.
Is there anything like that?
There was an attempt, my lord, but I don't know what is the report.
It
What?
was received on 6th of May.
কি লিখেছে? কি লিখেছে এবার?
Yeah, nine.
Reject করেছেন কি?
Hmm.
Yes, what report? Six May to it was again, right? 6 May it was available. Anything new? No, it was already. 6 May it was already recorded. In the order dated 21/5/2024. From the said communication, it transpires that the Inspector General of Prisons, Assam, has not yet submitted a proposal for remission to the state government with his recommendation. As the reports from the jurisdictional district commissioner and the superintendent of police are awaited. Be that as it may. So. It was there already.
Yes, yes.
It was video. Yes, Mr. Lord.
Yes, my lord, I have prepared a short synopsis with the relevant dates. Perhaps it would be convenient for your lordship. You can read it.
Yes, you're ready.
Right.
You have the paper book.
Lordship, I have the paper book. Actually, this was earlier seen by S.H. Bora, Lordship. She is not well. So she has handed the file now.
Have you gone through it or not?
Lordship, But if the learned friend wanted to start, Lordship, I will.
How many murders?
3, my lord.
3 murders.
That is there, Lordship.
You are not yet prepared.
Lordship, I have received the paper book, Lordship, because it was with her, Lordship.
Mr. Talukdar, 3 murders. Which has kind of preparation you did? What kind of evidence?
My lord, except the 164, there is no other evidence. And my lord, my only argument would be to show your lordships that the procedural safeguard, which is contemplated under 164, perhaps has not been followed. And there are Supreme Court judgments which says that violation thereof would reduce or would nullify the evidentiary value of 164. And therefore, the conviction solely resting on 164 cannot sustain, my lord, without any other corroborating evidence. There is, of course, my lord, 313, where he has, my lord, admitted. But 313 alone perhaps cannot form the sole basis for conviction, my lord.
He pleaded guilty also at the time of framing charge.
Guilty, but when the learned trial court proceeded with, my lord, so that would perhaps, my lord, would have no.
So, how many witnesses?
My lord, there are total 8 witnesses, my lord. Witness number
Let
1,
us see the order of framing charge.
yes, order framing charge is at page, my lord. Charge your lordship will find at page 9 of the 8 and 9, my lord, of the paper book.
No, it's here to sound. MS Begum, please
Lordship.
try to address on this issue. Suppose, at the stage of order framing charge, he pleaded guilty. And the learned session judge exercise his discretion to proceed with the trial. But whether at a later stage, that could be taken as a circumstance as regards the culpability of the accused. What was the date of framing charge?
My lord, it was
26.
framing of charge, it is 27/8/2008.
Just is of 220. It is Karbi Anglong or not Kasais?
Karbi Anglong,
Karbi Anglong. It was DC.
DC.
At that stage, is your deputy commissioner. Okay.
My lord,
What are the possible questions that will crop up? That is what I am.
yes, correct. 230 will be, my lord, in fact, interpretation of 230 will perhaps come in.
Some
That 229 and 230 are relevant
Hmm.
during the
CRPC.
sessions trial. So definitely, my lord, this question may come up. 239 is with regard to,
Normally, in case of, say, capital offences,
Yes.
when a person pleaded guilty, normally the trial court used to proceed, exercising the discretion. That appears to be proper.
yes,
Now, just take the other part. Suppose 229, if the accused pleads guilty, the judge shall record the plea and may in his discretion, convict the person. Now, if he does not, then he can proceed with the trial.
Yes.
Now, whether at a later stage, these could be taken as a possible circumstance or not. That is what I want to know. This point. One. Then, what about the confessional statement?
confessional statement, your lordship will find that
Annexer?
this your lordship will find at page 125, last page of the
125.
last but one page, my lord. 125.
Okay. Then why this is bad?
Uh,
Procedurally.
procedurally, my lord, in fact,
Otherwise, it is a confession.
yes. But in fact, what I will try to show that in fact, while recording the statement, my lord, in the light of the Supreme Court judgment, the magistrate must conduct a searching inquiry to find out, to inquire and to satisfy my lord himself that the confession is voluntary and it is free from threat, inducement or coercion, number one. And number two, my lord, if the accused, my lord, in fact, or the accused must be, my lord, given the assurances that even if he refuses, my lord, to make the confession, he will not be sent, my lord, to the police custody. Because on that fear, the accused might say something or confess, my lord. So these are the perhaps two requirements under 164 while recording the confessional statement. And what I find that there is violation of this particular two requirements, my lord. And number two, the magistrate recording the statement, he was testified. And my lord, his testimony with regard to the confession, my lord, itself, my lord, is contradictory or to some extent inconsistent with the confessional statement itself, my lord. If your lordship goes through his evidence, SPW 1, vis-a-vis, my lord, the confessional statement, your lordship will find some contradiction.
He should testify about the procedure he had followed. Going into the contents of the confessional statement, I don't think it is a requirement for him.
At least he should say what has been stated, because
But
he is the one.
what about you were produced from judicial custody or uh, police custody?
He was arrested on,
14 to 2000.
he was, my lord, perhaps on the police custody, my lord.
14 to 2005.
Because
Orders.
there was a 14 days remand. The appellant was forwarded by the police to the magistrate on 12 to 2005, 14 days remand. Then the confessional statement, my lord, was recorded on 17 2. So therefore, while he was, my lord, under police custody,
14 to
yes, it was
And
recorded on
17
17 2. 17 2,
17 to
yes. And
14 to
he was, my lord, forwarded by the police to the magistrate on the next day.
here to put up to record.
Forwarding report is 12 to 14 days remand custody, my lord, from 12 to would exceed 17 to. So while he
The
was,
record a confession statement or accused remand to. No, Mr. Talundar, it was jail custody.
jail custody.
On 14 to, it was jail custody. So that submission will not hold. Then when
Legally, my lord, what I'm trying to say, as a
then
proposition,
17 to, I was 1 minute. So it was JC till 28 to 2005.
Yes, well, can I put it in this way? As a proposition of law, but as a, my lord, under the CRPC, once, my lord, he is put to judicial custody, he cannot be again sent back to police custody. This is a settled provision of law under the CRPC. But, my lord, the convict, my lord, under 164, and in the light of the Supreme Court judgment, he is entitled to know that even if he refuses to make the confession, man, or to give the confessional statement, he will not be sent to police custody, because this is a requirement to give him the solace. man.
Right, but
Yes.
so far that turns out to be not a correct one, that police custody. Let us see how he was produced.
Yes.
Madam, find out the orders for 17-2,
Okay.
right? Because here after 14-2 in the order sheet, straight away to 28-2. There is no proceedings. In between of 17-2. And but handle the records very carefully. It is very delicate. Find out all these factors that he was remanded to judicial custody on 14-2. Next date in the order sheet is 28-2. The magistrate deposing as PW 1 or 2, whatever, he said that on 17-2-2005, his statement was recorded. So far, 17-2 is okay, 3 days for reflection in judicial custody. That is okay. Then on 17-2, another 1 hour for reflection. Then thereafter, the other procedural formalities. Then 164 statement. Now, find out from the records whether there was compliance of those procedural safeguards. Then what else? No eyewitness.
No eyewitness.
No eyewitness.
In fact, what has happened, my lord, in 2020, if I recollect correctly, my lord, this matter was sent back to the learned session judge by division bench, my lord. And
Then-
for, yes, recording additional evidence.
Okay.
But thereafter, my lord, the report came back that no witness could be found. So attempt was made, my lord, to record the
1
statements of
minute.
the witnesses. That your lordship will find 31/2020 order.
I'm reading.
Yes, ma'am.
Then why later date you have not highlighted this point?
my lord.
Why on the subsequent dates you have not highlighted that point?
No, there is an order. I have highlighted before the, my lord, division bench.
Because after taking the evidence of those witnesses plus the evidence of the eyewitness,
Yes.
matter should be sent back to the appellate court,
My lord.
right? Record shall examine and send the record along with the deposition and the request certificate as contemplated under section 391.
Ah.
Thereafter, nothing has been recorded.
No, my lord. What has happened? The entire file were sent back,
Right.
LCR, etc.
Hmm.
Thereafter, my lord, finding no witnesses. My lord, I think, my lord, there is a report from the session judge
Let
that
us
no
see.
witness could be found. And thereafter, the same file, my lord, was again sent back to the honorable court.
Let us see then. The report, if any, is available.
No evidence is recorded, my lord, thereafter. Because none could be found, my lord. No witness could be found. I recollect, my lord, I have gone through, my lord, the some report. my lord.
Immediately. Huh? Right, right here. Flag A, B, এটা করেছে। ও C report. Flag A1. Flag A2 was also. The wife of the accused,
My lord.
she was asked to be examined. So far that lady is concerned, she expired. But the order is, if I remember correctly, huh?
Here the direction was, accordingly, we provide that the evidence of the witnesses who sustained injuries in the occurrence and also the eyewitness of the occurrence, namely Bhanu Maslai, shall be taken as additional evidence by the learned session judge.
Now again it appears to be perfunctory. Yes.
I have seen it, sent on 12.
Only someone was issued to Bhanu Maslai. Report came from the OC, she expired. Session just forwarded the matter back again without reporting anything on the evidence of witnesses who sustained injuries in the occurrence. This is the fate of this appeal.
It does not indicate anything whether any effort was made to collect evidence.
Zinara Mamsi, Noldon Maslai, Homen Mithi, Shankar Mithi, Lord Sriram, besides the so and so. This is the, this cannot, this order does not appear proper. I think we should ask,
I'll leave it to you.
It was first sent on.
you should have highlighted it earlier.
In fact, it escaped my mind. In fact, on the earlier occasion to the Honorable Division Bench, I had indicated that there is an earlier order. But
Because
today,
we
I-
normally see the previous order.
Yes, correct, my lord. I
But,
take it on myself. I ought to have, before starting, I ought to have pointed out to your lordship's man. But it escaped my mind, my lord.
It was listed in April
Mind.
and you highlighted that remission part.
Yes, on the,
So we proceeded with that remission part.
yes, in fact,
But this,
in the interregnum, my lord, in the interregnum, the entire matter proceeded on that direction, on the remission part. On the last occasion, when my learned friend said that perhaps, my lord, it is going to be rejected, then only, my lord, I started preparing the case.
but you should have
Correct, my lord. That I
highlighted
have to have pointed out. today,
that
my
this
lord.
is a order which
Yes.
is not in conformity with the power order exercised by this appellate court under 391.
Correct.
Because the order itself reflects the name of the 5 injured persons.
My lord.
And this is the order.
My lord.
You should have highlighted it. And by that way, you are in jail also.
My lord.
2 years unnecessarily gone by, and now these witnesses, whether we don't know,
Yes. My lord, in
this
fact,
way or that way, this is difficult, Mr.
Yes.
Talukdar. You should have highlighted it.
my lord, in fact, while going
Now
for the,
PP is not highlighting it. Court has, after meticulous examination of the record, has passed that order.
this is of 2020. My lord, what has happened? This is of 2020 order. In fact, while going through the report, perhaps that was, my lord, mistake on my part. I did not compare the directions, my lord, of this honorable court. I have gone through the report that, my lord, the witness had died. So therefore, my lord, I thought that nothing has.
One witness died, total 6 was directed
Correct,
to be
my lord.
examined.
Yes, while going through that report, my lord, in fact, perhaps I did not go through the, my lord, the order passed by this honorable court. Exactly what was the direction, man?
But Mr. A.S.K. Talukdar learned amicus curiae for appearing for the appellant, NMS A. Begum learned additional public prosecutor for the respondent state. So, during during the in the course of deliberation, in the course of hearing on an earlier on a previous date, date is on 30/1/2020. Please quote, after hearing the learned counsel for the parties, had made the following order. Believe is made an order in exercise of the power under section 391, Code of Criminal Procedure 1973. Full stop. That's a para. The relevant excerpts of the order dated 30/01/2020 are as under 31/2020 যিটো আছে তাৰে এইটো কোড কৰি দিব পেন্সিলে দাগ মাৰা আছে হ'ল the case records of sessions case number 18 of 2007 stood transmitted to the Court of Learned Session Judge Karbi Anglong Difu on 11/2/2020 to proceed according to the observations and directions given in the order dated 30/1/2020. Full stop. Thereafter, the case records of sessions case number 18 of 2007 had been received back from the Court of Learned Session Judge Karbi Anglong Difu by the memo dated 28/10/2021 along with a copy of the order, copy of an order dated 27/10/2021 passed by the Learned Sessions Judge Karbi Anglong Difu in Sessions case number 18 of 2007. First stop. Para. For ready reference, the order dated 27/10/2021 passed by the Learned Sessions Judge Karbi Anglong Difu in Sessions case number 18 of 2007 is quoted here and there. In its entirety. এইটো On a on perusal of the order dated 30/1/2020, comma, no, no. We find that it had been clearly observed therein that the court, after going through the evidence stroke materials on record, found that besides the death of 3 persons, comma, a number of persons sustained grievous injuries in the same occurrence, and they were Zinaram 1, within bracket 1, Roman 1, Zinaram Amsi, 8/31/2020 order. তারই নাম কেটা আছে। 2, Noldoi Maslai. 3, Homen Mithi. 4, Shankar Mithi. And 5, Lokim Maslai. Besides the accused appellant himself. Full stop. The court also recorded that one Bhanu Maslai was the eyewitness of the occurrence as deposed by the other cited witnesses. Full stop. It was after observing as above, comma, the court on 30/01/2020 had observed that the evidence of the witnesses who sustained injuries in the occurrence and also the eyewitness of the occurrence, namely Bhanu Maslai, shall be taken as additional evidence by the learned sessions judge. Full stop. When stop. But from the order dated 27/10/2021 passed by the learned sessions judge in sessions case number 18 of 2007. But in the order date, in the order, there is no reflection that the that any endeavor was made to secure the attendance of the aforementioned 5 persons, comma, who were stated to be injured, who were stated to have sustained grievous injuries in the same occurrence. Full stop. 7 accept recording, full stop. 7 accept recording that Vanu Maslai was found to have expired on 25/9/2019. The order dated 27/10/2021 is silent on the aspect regarding examination of the aforementioned 5 witnesses. Full stop. Not to speak of about any endeavor to compel the attendance of those witnesses. Full stop. In this connection, it is apt to mention that this court, in the order dated 30/01/2020, had observed that to complete the exercise, the Court of Learned Session Judge, if necessary, shall compel the attendance of the witnesses. Sessions does not trial court করে দিবে. So good. Full stop. In the above facts situation of above obtaining fact situation, we are persuaded to hold a view that the exercise undertaken by the learned trial court was not in conformity with the order dated 30/01/2020. Full stop. Para. The report from the learned trial court was received in December 2021. Full stop. But, no, full stop. But, this aspect has not been highlighted by the learned counsel for the parties during a subsequent period on subsequent dates when the appeal was listed. Full stop. Para. Having noticed, it is pertinent to, it is pertinent to mention that the accused appellant stood the trial for the murder of 3 persons. 3 or 4? 3 men. 3 persons. Para. Noticing the gravity of the situation, we are compelled to order that the learned trial court shall undertake the exercise of recording additional evidence of the aforementioned 5 witnesses in conformity with the observations already made in the order dated 30/01/2020. Post of para. For facilitating the original records of the learned session judge be transmitted immediately if necessary by a special messenger to the Court of Learned Session Judge Karbi Anglong Difu. Full stop. To facilitate the Court of Learned Session Judge to complete the exercise as expeditiously as possible, preferably. Not within a period of 4 months from the date of receipt of the record. Post stop. We reiterated that if found necessary, the learned trial court shall compel the attendance of the witnesses. Full stop. Yes.
Well, I need to clarify one thing. On 16/3/23, about more than 1 and 3-4 months back, my lord, after the records were, my lord, sent back to this honorable court, my lord, hearing took place. It's on record. And my learned friend, Julie Jahan, my lord, represented the prosecution. So in fact, my lord, the argument was also concluded. And I pointed out the honorable court with regard to the report of the, my lord, learned session judge.
16/3/2023. There is no reflection about it.
My lord, in fact, no reflection about the hearing, my lord.
No
What-
reflection about the hearing, no reflection about the remanding back the matter by the learned session judge. Everything hovered around remission.
Exactly what I'm trying to say. After, my lord, conclusion of the hearing, the learned, my lord, court directed me to pursue the matter in respect of the remission. And thereby, the issue, my lord, with regard to the report and additional, my lord, evidence, etc., it subsided, my lord.
Receded into the background.
Yes, my lord, it subsided and only surfaced, my lord, today, when the remission, my lord, is virtually
But
rejected.
we don't know. We handle
No,
the case.
exactly, my lord.
As and when we get the roster.
Absolutely.
But
my
the
lord.
councils are constant.
Exactly, my lord. What I'm trying to say, what happened exactly, my lord, in this case? This is why, my lord, perhaps, my lord, it subsided.
See, in a case, it is a case of 3 murders.
I understand, my lord, the gravity of the offense. my lord.
And you are an amicus.
Correct, my lord. Yes, I take
So,
the responsibility. also.
responsibility-
Yes, yes,
Should be on you
yes, sir.
so that the justice,
I represent. the court.
Prevails.
Yes, exactly, my lord.
not a privately engaged counsel.
No, no.
Now, if there are 5 witnesses, situation is completely different.
Yes, different, my lord. And entire trajectory of
Injured,
the,
injured witnesses.
yes, the entire trajectory of
Their-
the case, my lord, will change.
Their status as a witness
Yes, yes,
are on a much higher pedestal.
yes, correct, my lord, because they have sustained injury, my lord.
Nobody is highlighting this. We just flip through the pages,
My lord.
then we got done.
Yes,
for
I
this.
understand, correct. Obliged.
This 2 years have gone by in the meantime.
Yes, due to the remission part, my lord, nothing else. Obliged.
Yeah, no, yeah. Yes, after. After after the appeal is to be listed after receipt of the case records of sessions case number so and so from the Court of Learned Session Judge Karbi Anglong before. It last part, it was the last.
Item number 2.
Lordship, kindly pass over the matter for the time being. My senior is on legs, Lordship.
Lordship, I prayed for some time. Paper book is not available with us. Paper book is not there. Paper book is not available.
Paper book is not available.
Matter relating to POXO, mine. I prayed for taking up this matter after a week.
POXO,
Yes, ma'am.
On behalf of respondent number 2, my lord. But my lord, I have not received paper book, my lord.
paper book, all paper book.
120 matter, madam.
Huh?
120 matter, madam.
Paper book not received.
So, my lord.
Okay.
24.
C. Dotto. Stick.
What was it? 21 now? Paper book was ready on 21, my lord, in the year, but already, my lord, COVID, COVID period started that.
Received.
Well, I have extra paper book with me, madam. I can-
Say extra.
Right now, I can see that. I have an
You have extra?
That will be given.
See the benevolence of Mr. Mahajan. He is
Lordship,
handing over.
that will be given to me.
Huh?
The extra copy will be given to me, madam.
You don't have? Huh? You also don't have paper book. Paper book you also received in 2021, January. And who was Lohit Gogoi? Lohit Gogoi, isn't he? Lohit Gogoi, he's from this side. Okay. Now your grievance is redressed?
Yes, my lord.
Okay,
I
only
have
be
received.
Bhuya now. Okay. And Mahajan for the
8 people were convicted, faced trial. Only 3 convicted, my lord. 30
for the appellants, B. Bhuya, Senior Counsel and Additional Public Prosecutor for the respondent number 1 state, and MS P. Bordoloi, PB Bordoloi, Learned Legal Counsel.
No, my lord.
Learned Counsel for the respondent number 2. Post. By এইখিনি আগৰটো repeat কৰি দিব। B. Bhuya. আগৰটো repeat কৰি দিব, 1 week ভিতৰত paper book. Huh? To B. Bhuya.
Highly
What
obliged.
to do?
May I pray for a shorter. for
1 week.
1 week time, madam. Obliged to failure.
Item 4.
Five lakh 50.
Yes, yes, Lordship.
Latin.
Yes, The conviction under section 302.
Madam, PP, available, paper book.
Paper book is there, Lordship. And Lordship. Eleven PW. 11 PW.
Hmm?
11 PW and CW 1.
25.
The fire is at page 1. Lord.
Yes.
Date of occurrence is Thursday, 14/5/2020. Time, however, is not recorded. But the information was received 6 days later on 25/20 at 11:15 AM. Place of occurrence is village number 2, Shantipur, PS, Musalpur, District Baksha, BTAD, Assam.
Yes.
Complainant is the PW2 in this case, Amrit Brahma.
Okay, let us see the doctor evidence first. PW1 is already there.
At page 9, Dr. Manoj Majumdar. On 25/20, I was posted at Dr. Ravi Boro Civil Hospital as senior M and HO. I conducted the postmortem examination on deceased PC Ramsiari, female aged 48 years, wife of Sri Leben Ramsiari, village number 2, Shantipur, PS, Musalpur, District Baksha on 25/20/20 at 4:15 PM in connection with Musalpur PS case number 41/20 under section 302 IPC. The dead body was escorted and identified to me by UBC 222 Rahul Borman and Sansima Doimari. On examination, I found the following: external appearance, partially decomposed female dead body without cloth, mud and sand particles present over the body. Eye and mouth are partially open, body cold, rigor mortis passes out. Cut injury of 10×2 centimeter, bone deep, present over front of neck, 4 centimeter above sternoclavicular joint. Multiple cut injury of sizes ranging 10×3 centimeter, muscle deep to 5×1 centimeter present over waist, buttock, back, hands and thighs. Black stain is present around the margin around the injury. No ligature mark detected. Injury as described. Cranium and spinal canal. Scalp as described. Skull is healthy. Vertebra is described. Membrane healthy. Brain semi-liquefied. Spinal cord not examined. Thorax walls are as described. Rib and cartilage healthy. Pleura healthy. Larynx and trachea as described. Both lung partial decomposed, pericardium healthy, heart healthy, vessels healthy. And the next page, abdomen, walls as described, mouth, pharynx, esophagus partially decomposed, stomach partially decomposed, small intestine partially decomposed, large intestine partially decomposed, liver partially decomposed, spleen partially decomposed, kidney, both kidneys are partially decomposed, bladder partially decomposed, organs of generation, external and internal, uterus healthy and empty, muscles, bones and joints, injury as described, disease and deformity not detected, dislocation not detected. Opinion is that death was due to injury sustained in the body. All injuries are antemortem and caused by sharp cutting weapon. Time since death 3 to 7 days. Exhibit 1 is my postmortem report. Exhibit 1 is my signature. Exhibit 2 is the signature of Sri Sharma, Superintendent of Ravi Boro Civil Hospital. Exhibit 2 is the inquest report. 2-1 is my signature. 3 is the dead body. 3-1 is my signature.
Okay, this Somnath Sharma,
Is my
as per the FIR, it was before him, it was confessed. Let us read first Somnath Sharma.
Page 13. I know the informant Amrit Brahma. I also know the accused standing in the dock of the court today. I also know deceased occurrence took place in the month of May 2020. On a particular day in the month of May, accused Leben Ramsiari came to my house early in the morning. He disclosed to me that he had killed his wife, Fishy Ramsiari. Then I took the accused with me to his village. Then villagers gathered. Before the villagers, in my presence, the accused confessed that he had killed his wife, Fishy Ramsiari. Thereafter, we called the village mail and informed the police. In the village mail, also the accused had confessed that he had killed his wife. I informed the police over telephone. Police came to the village of the accused after half an hour of the village mail. Executive magistrate also accompanied the police at that time. Before police and magistrate, the accused confessed that he had killed his wife. In the house of the accused himself, his wife and their minor child were living prior to the occurrence. When police asked the accused about the dead body, then he himself dug the earth under sang of his house and fetched the dead body of his wife. He stated that he had killed his wife by a kukri. He has also produced the kukri to the police. Police seized the kukri in my presence by preparing a Caesar list. Caesar list at page 87, notes. Page 93.
Page 90.
3 is the Caesar list. And 87 is the exhibit 2 inquest report.
Page
87 is the inquest report.
87. Place 120. Santipur Leben Ramsiari, who showed the dead body. Identifying the dead body
Before that, my lord,
around
page 85, death was due to injury
dead
sustained.
body.
All injury antemortem and caused by sharp cutting weapon.
1 minute. Where is the PM? Chalan.
Page 81 is the postmortem report.
Seizure list.
Page 93. A Nepali kukri made of iron having a wooden handle. The length
18.
is about 18 inches.
18 and postmortem. Postmortem.
At page 81. Opinion of the assistant surgeon at page 85. Death was due to injury sustained in the body. All injury antemortem and caused by sharp cutting weapon.
So before PW3,
My lord, is the
this part that of his testimony that you came to his house early in the morning and disclosed that you had killed his wife. has not been contested or disputed in any manner when he was cross-examined
In his 313, he has not denied this.
in cross-examination.
Yes.
Has not been disputed.
Yes, sir.
And then second part, then he took you to the villagers, and before the villagers, in his presence, you again confessed.
Yes, sir.
So this appears to be then thereafter police came. That will be by 25, 26. But so far as this part is concerned, it will be under 24. There was no coercion, no pressure, no threat.
Yes, ma'am.
Section 24. You have not disputed anything. You cross-examine him, see the trend. Absolutely nothing about the confession. Okay, it cannot stand alone, but this is a piece of evidence. Section 24, what does it say?
Confession caused by
Admission or admission. 24.
17, admission defines, and admission is a statement, oral or document.
Confession caused by inducement, threat, or promise when irrelevant in criminal proceeding. A confession made by an accused is irrelevant in a criminal proceeding if the making of confession appears to the court to have been caused by any inducement, threat, or promise, having reference to the charge against the accused person, proceeding from a person in authority and sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supposing that by making it he would gain any advantage or avoid any evil or temporal nature in reference to the proceeding against him. Nothing is absent. Whatever is mentioned here, no inducement, no threat, no promise by PW3. So it appears relevant, and he is not a person in authority that by making disclosure before him, he'll be free of the charge or he'll be given any benefit. He is simply Gambura. So this part appears to be adverse towards you. Let us see PW. 2. Informant.
Page 11. Lord. I am the informant of this case. I know accused Leben Ramsiari, who is my co-villager. I also know deceased PC Ramsiari, who was the wife of the accused Leben Ramsiari. Accused Leben Ramsiari addressed me as maternal uncle. The occurrence took place in the year 2020. The accused, having murdered his wife Fishy Ramsiari, covered her dead body by digging earth inside his house. When Fishy Ramsiari was not seen by the neighbors, they started searching her, but did not get any clue. After about 6 days of occurrence, accused Leben Ramsiari himself visited Government Gaubura Somnath Sharma and confessed that he had killed his wife. Thereafter, the accused, accompanied by Gaubura, informed the villagers at Village Mel. I was the president of Village Mel. The accused confessed before us that he had killed his wife and dug her under the soil inside his house. Then we informed the police. Police came and took custody of the accused. Executive magistrate also came with the police. I, along with the Gaubura and other villagers, were present with executive magistrate and police at the house of the accused. The accused then dug the earth of his dwelling house and took out the dead body of his wife. The accused confessed that he had killed his wife by stabbing her with a sharp cutting weapon. The accused himself produced the offending kukri to the police. Today, I have seen the kukri which the accused produced before the police. Material exhibit 1 is the said cookery. Police seized the cookery in my presence by preparing a Caesar list. Exhibit 1 is the FIR lodged by me, and Exhibit 11 is the signature. TW3 Somnath Sharma, the Gaonbura, informed police orally over phone before lodging the formal FIR by me. Police recorded my statement during the investigation. I lodged the FIR as I am the president of my village. What the accused stated before the Gaonbura at his house prior to the village mail, I could not say. It is not a fact that in my previous statement before the police, I did not state that the accused dug the earth of his dwelling house and fetched the dead body of his wife. It is not a fact that in my previous statement before police, I did not state that police and executive magistrate came to the house of the accused. Generally, cookery-like material exhibit, it is kept almost in every family of our village. It is not a fact that material exhibit 1 was not used in committing murder of the wife of the accused. The wife of the accused used to visit others, so the accused quarreled with her. I never saw the wife of the accused mixing with other male of our village. It is not a fact that the accused himself did not murder his wife and kept her dead body under the soil inside his house. It is not a fact that I am falsely deposing that the accused did not confess that he had committed murder of his wife.
Again, confession part was not challenged. Yes,
PW11.
PW11.
Yes, my lord, the ASI of police, who was in charge of Nikasi police outpost and made the GD entry. He says that on page 29, on 25/20, I was in charge of Nikasi police outpost under Musalpur PS. On that day at about 10 a.m., Sri Amrit Brahma, President of Village Number 2, Shantipur, came to the police outpost and lodged a written Ezahar. After receiving the FIR, I made GD entry number 339 dated 25/20 and forwarded the same to the officer in charge of Musalpur Police Station for registering a case under proper section of law. On the same day, I recorded the statement of the informant under 161 TRPC. On being authorized by the officer in charge of the police station, I took up the preliminary investigation. In the meantime, I had intimated the details of the occurrence to the officer in charge, SP and District Magistrate Baksa. I gave formal requisition to the District Magistrate for deputing a magistrate under his control to exhume the dead body and conduct the inquest. I accompanied by officer in charge of Musalpur PS and Mr. Manoj Kumar Dole, Circle Officer Musalpur, visited the place of occurrence. Accordingly, I arrived at the house of the accused, Leben Ramsiari, in village number 2, Shantipur. I interrogated him in presence of the public who had already gathered there. The accused confessed before me because of family quarrel. He on 14/5/20 at night committed murder of his wife Pishi Ramsiari inside his house by slashing her with a kukri. He also confessed that he covered the dead body under earth by digging a hole inside his house. Thereafter, the accused himself in presence of me, other police personnel, the executive magistrate, and other public, including Gaubura, dug out the dead body of his wife, as there was a foul smell coming out from the partially decomposed dead body. The police personnel made audio-video recordings. This has not been exhibited through mobile phone of the entire fact of digging out the dead body inside the house by accused Leben Ramsiari. Said Circle Officer Musalpur made an inquest, that's at page 87 to 90, on the dead body of Pishi Ramsiari. Thereafter, the dead body was sent to Musalpur Civil Hospital for conducting post-mortem examination. At the time of digging of the dead body, I took custody of the accused. He also brought out the offending kukri from inside his house and handed over to me. Accordingly, I seized the same in the presence of the witness. The seizure list was signed by witnesses and the accused. The kukri was not sent to FSI for serology test. I drew the sketch map of the place of occurrence in the presence of the witnesses. I also recorded the statement of all the witnesses under 161 CRPC. The accused was formally arrested and produced before the court with a prayer for sending him to jail custody. I collected post-mortem examination of the deceased. Upon completion of investigation, I laid charge sheet against accused Leben Ramsiari under section 302 and 201 IPC. Exhibit 1 is the Ezahar, 1-2 is my signature, 1-3 is the signature of O.C. Ratneshwar Burman, Musalpur PS, the sketch map is Exhibit 5, the place of occurrence, and Exhibit 5-1 is my signature. Exhibit 4 is the scissor list, 4-3 is my signature, 4-4 is the signature of accused Leben Ramsiari. Material Exhibit 1 is the offending kukri which I seized on being produced by the accused at his house. Material Exhibit 2 is the compact disc CD from the audio-video recording of the scenario of exhume of the dead body of Pishi Ramsiari at the instance of Leben Ramsiari at his house. Exhibit 3 is the dead body Salan, and Exhibit 3-2 is my signature. Exhibit 2 is the inquest report. 2-4 is the signature of Manoj Kumar Dole, the circle officer of Musalpur Revenue Circle. Exhibit 6 is the charge sheet, and 6-1 is my signature. 6-2 is the signature of O.C. Ratneshwar Burman. On cross, he says that the local Gaubura at first informed me about the occurrence over telephone, but I did not make any GD entry of the said information. It is not a fact that immediately after receiving.
Okay. We'll come back.
cross
Hmm.
of the AS. The local Gaupura at first informed me about the occurrence over telephone, but I did not make GD entry of the said information. It is not a fact that we immediately after receiving telephonic information of occurrence, we came to the place of occurrence. It is not a fact that on the spot we received the formal Ezahar. At 10 a.m., we came to the house of Leben Ramsiari. The case was registered as so-and-so at 11:15 a.m. on 25th, 2020. In Caesar list, the specific time is not mentioned. In Exhibit 4, Caesar list, the place of Caesar is also not mentioned. I did not find any eyewitness to the actual occurrence. I recorded the statement of Charam Ramsiari, 9-year-old son of Leben Ramsiari. I have not mentioned in the charge sheet as regards the family quarrel existing between the accused and his deceased wife prior to occurrence. During investigation, it was revealed that Charam Ramsiari, 9-year-old son of Leben Ramsiari, was also present on the relevant nights of occurrence at his house. PW through Amrit Brahma in his previous statement did not state to me that the accused himself had dug out the dead body. PW4 Sonaram Goyari in his previous statement did not state me that the accused confessed before him that he had killed his wife and kept the dead body by digging earth inside his house. PW6 Sansuma Doimari in his previous statement did not state before me that the accused himself had produced the kukri before the police. I did not record the statement of the witnesses who made audio-video recording of the scenario leading to exhume of the dead body of the accused inside his house. I did not take the original video footage of the mobile phone by which audio-video recording was made. He has stated that by using his mobile phone, the audio-video recording was made. I did not seize the original memory of card and the video print of the mobile by which audio-video recording was made. Exhibit 2 is under objection from defense side. It is not a fact that I did not properly investigate the case and suppress the original information furnished by the Gaupura. Then there is a child witness at page 33, Charan Ramsiari. He was the son of the accused. The witness is the child witness, aged 10 years only. In order to ascertain whether he is capable to testify, the following questions are put and answered, given to him are recorded. It is very relevant to mention here that the child witness does not understand Assamese language. As such, Sri D. Boro, learned additional PP, put the questions in Boro language, which are translated to him in Assamese language. Similarly, the answers given by this child witness in Boro are recorded in Assamese on being translated by the learned additional PP. His statements are at page 34, Lordship. And then question number 1, where and with whom you have come today? I have come to Bhataupuri court with the village headman and my relatives. I have also come with my cousin, Sun Somar. Do you go to school? Yes, I go to the primary school of our village, Santipur. In which class do you read? I read in class 3. What is the name of the headmaster? So and so. Then what happens if anyone lies? What is your mother's name? He answers the Spishi Ramsiari. Where is she now? She is no more. She was being hacked. Who hacked your mother? My father, Leben Ramsiari. Where did the witness incident took place? One night, the incident took place inside our house. Then page 35, how did you come to know that your mother was hacked? On the night of occurrence, when I fell asleep, my father woke me up. My father asked me to hold the torch. I did not flash the torch. My father flashed the torch and kept it on the bed. My father hacked my mother by using a kukri. Before my father hacked my mother, the latter had taken me on her lap. My mother screamed, but he was not injured, my dear. After hacking my mother, my father dug a ditch inside the house and buried her there. What did you do after the incident? I fell asleep. Then at page 36, you woke when your parents quarreled with each other on the night of occurrence, isn't it? I was sleeping, therefore I cannot say whether there was any quarrel that took place or not. How long did your parents quarrel with each other after your father had woken you up for a short while?
Yes, what is your submission now?
He says that before his father hacked his mother, he was in her lap, but
Hmm?
he was not injured. At page 35,
Page 35. Yes,
he said that when my father hacked my mother, the latter had taken me on her lap. My mother screamed.
hmm.
But he was not injured.
He was not assaulted.
But
Father was careful enough not to inflict any blow on the son. How he can be disbelieved?
he's a child witness, that's fine, my lord, but he had come to before it's there. He was with somebody else when he came to
Somebody else should not. Hmm?
he was with the village headman. I have come to Bhattapuri court with the village headman and my relatives. I have come with my cousin Sun Sumar.
How does it affect the case of the prosecution? Definitely, his mother was not there and father was in jail. He had to be with his relative only. And a village, presence of village headmen would lend more assurance.
PW3.
Confession part you did not challenge. Neither before the Gamura nor before the villagers prior to arrival of police. And you admitted in 313.
In 313 at page,
And why these witnesses are to be disbelieved? They are your co-villagers. Not that they are relatives of your wife. They are co-villagers, independent witnesses. You have not brought out anything that they are inimically disposed towards you. And they did not inquire. They found that your wife was missing. But you yourself went to the village headman and made the disclosure. And that was on 14th. And 14th, you say that your wife was dead. On 20th, you made the disclosure. Everything happened on 20. Then postmortem says also 6 to 7 days. And that part, Kukri, you handed over, though you denied in 313.
he said that he did not
And
his wife.
yes, denied somewhat in 313.
Yes, I have.
But that Kukri goes in conformity with the nature of injuries sustained by the deceased. Sharp cutting weapon, autopsy doctor says. And that was buried inside your house, how can somebody else can come to your house and dig out earth, bury the dead body, and went away without your notice? So that is also a circumstance which goes against you. Over and above, the child witness clearly implicated you as an eyewitness. Anything on law?
Section 25, Lord.
Hmm?
Section 25 of the Evidence Act.
Yes, there 3 times confessions were made. One before PW3 or two. Two. Second time before other villagers. At that time, there was no presence of police. Third time, police arrived, then again you confessed. So third time it will be hit by 25. But what about first and second time? Any force, coercion, threat, or the person in authority, everything was absent for the first time disclosure, second time during second time disclosure. So extra judicial confession is also a piece of evidence, substantive evidence, though of weak nature. It needs corroboration from other evidence. The factum of handing over the kukri, postmortem report, 6-7 days, sharp cutting weapon, eyewitness, how do you displace them? It gets sufficient corroboration prima facie. Anything which is to be disbelieved that somebody else, which you said in 313, when it goes against you, then that is an additional circumstance. If you put up a false explanation, that would be again additional. How can 3 persons can come? And that was not your story during the cross-examination. Is it not? You never made any suggestion to any of the witnesses that this man who you have named for the first time, who?
Yes,
Hmm?
my wife.
One Hitesh Doyamari, Subhas Narjari, right? And second part, members of BPF party. If had it been so, you would have been the first person to inform the police. You remain a mute spectator. Subhas came, Hitesh came and killed your wife, and you, as the husband of your murdered wife, remain silent for 6 days. Is it believable? Tell me. And secondly, BPF party got your wife drunk, committed bad act, and you remained a silent spectator. That story, is it believable? You should have been the first one to go to police
Therefore,
to inform that this man, Hitesh Subhas, they killed my wife. What prompted you to go to the Gambura and confess, taking the blame of Subhas and Hitesh? And moreover, the body was not somewhere else. It was inside your house. And your son. You know the place where the dead body was. Anything? Tell us what submission you have prepared. Anything from the defense, please, from cross-examination? You sought to contradict, but that contradiction is not contradiction. That attempt that I did not state so and so before the police, then that part of the previous statement should have been marked and got it confirmed to the IO. That was also not done because of the fact that I think commitment order. Your the defense legal aid counsel did not put up any plea all throughout the trial. Yes, sought to contradict few of the witnesses, but never contradicted about confession. Never challenged the confession. Regarding some previous statement, he put some suggestions. Yes. Yes, anything?
Also, when the eyewitness also, while he was sleeping, his father woke him up and gave the torch also to. That is that no tutor is there because he already is what he have seen is he has reflected that because he has.
but my lord, he was saying that he was in his mother's lap. He was in his mother's
At the
lap,
last moment,
so he was not injured her.
he will not be injured, Lordship. His confession is also relevant, corroborates with the doctor injury with sharp cutting weapon.
No, it is 24 hours SCR. Section 27 oral hello finding it out. Section 27 of the Vansara thing that
Multiple cut injuries are also in the back, both of. So, the child is also not. waist, buttocks, back, hand and thighs.
মানে ডিস্কভাৰী মানে সেইটোৱে নহয় তাৰমানে ৰিকুৱেষ্ট লিখিব লাগেতো ভেৰি ফাইন হৈ লিখিব লাগেতো ইয়াতে আৰু বেলেগ প্ৰচেছত হেৰি সেইটো কাৰণে জানাতো জানা যায় it is reflected in the order that is a difficult ইয়াতে কুৱেশ্যন নাই আৰু style difference ওলাব 227 huh why attitude okay please take your seats okay let us see the judgment
At page 45, Lord. 46 it starts. Points of determination at page 49. Whether accused Levin Ramtheri on or about the night of 14/5/20 intentionally and or knowingly caused death of his wife Pishi Ramtheri inside his house and thereby committed offense of section 3 under section 302 IPC. Evidence submission of the legal aid counsel is then recorded. Evidence of child witness, Karan Ramtheri, 10 years old, who is the son of the victim and the accused at page 60, Lordship, para 30. It's most relevant to mention here that CW1 is the student of class 3 at number 2 Santipur Gaon LP school. He does not understand the Assamese language. In order to ascertain as to whether he is capable to testify, questions in Assamese language were put to the child, translating it into Boro language by learned APP, who belong to Boro community, is well conversant with the language. The answers given by the child in Boro language was translated by the Assamese language to Assamese language by the additional PP. In order to ascertain the evidence is recorded fairly without any deviation to what the child exactly says. So and so who belongs to Boro community was present and assisted by so and so, the legal aid counsel. Para 31, the
the instant criminal appeal from jail under Section 383, Code of Criminal Procedure 1973. Is preferred against a judgment, an order dated 23/09/2021, passed by the Court of Learned Sessions Judge, Baksa at Mosholpur in Sessions Case number 50 of 2020, which arose out of Musalpur Police Station case number 41/2020 and corresponding. PRC case number 834 of 2020. Full stop. In the trial before the Learned Sessions Judge, Baksa, the accused appellant faced a charge of murder under Section 302, IPC. Indian Penal Code. And after the trial, the learned session judge Baksa within bracket the trial court for short, finding the accused appellant guilty of uxoricide for committing the murder of his wife, convicted him under section 300, IPC. And after hearing him on the point of sentence under section 235 within bracket 2, sentenced him under section 302, IPC. Where is the sentence part? Sentence part to control.
Page 79.
Page
79.
79. Sentence him to undergo rigorous imprisonment for life and to pay a fine of rupees 2,000, in default of payment of fine, to undergo rigorous imprisonment for further 6 months. Full stop. Para. The case of the prosecution, in brief, is that investigation was launched on 20/05/2020 when one Amrit Brahma as the informant lodged a first information report before the in-charge, Nikasi outpost, alleging that the accused was behind the murder of his wife, PC, PHISHI, PC Ramsiari on 14/5/2020. First off. On receipt of the FIR, the in-charge Nikasi outpost Mukunda Das within bracket PW11 registered the same as Nikasi outpost general diary entry number 339 date 20/05/2020 at 10 a.m. and forwarded the FIR to the officer in charge Mushalpur Police Station for registering a case under proper sections of law. Full stop. On receipt of the FIR, comma, the officer in charge Mushalpur Police Station registered the same as Mushalpur Police Station case number 41/2020 for the offences under section 302, IPC and section 201, IPC. Full stop. The in charge, Nikasi outpost, Mukunda Das, a sub-inspector of police, had already taken up the investigation of the case on being authorized by the officer in charge, Mushalpur Police Station. Full stop. Para. In the FIR, the informant, who also testified as PW1, had inter alia mentioned that on 20/05/2020, the accused, Leban Ramchiari, a resident of number 2 Santipur, resident of village number 2 Santipur, police station, Moshalpur, confessed before the government village Gaambura, Homnath Horma, that on 14/5/2020, he had killed, within bracket, the accused, had killed his wife, Fishy Ramsiari, with a kukri over domestic issues and kept the body buried under the floor of his house. Full stop. Para. While carrying out the investigation of the case, the IOPW 11 recorded statements of a number of witnesses under section 161, CRPC. Full stop. The dead body of the deceased was dug out. Dug out, hello, correct. From a place inside the house of the accused on 20/05/2020. Full stop. After digging out the dead body, inquest proceeding was conducted. At that place itself by an executive magistrate on 25/2020, full stop. Thereafter, comma, the dead body of the deceased, comma, Ishi Musahari was forwarded to Dr. Robi Boro Civil Hospital at Mosulpur for performing postmortem examination. Full stop. The postmortem examination of the dead body was performed at Dr. Robi Boro Civil Hospital, Mosulpur on 25/2020 itself. Full stop. The IO, comma, in the course of investigation, comma, also made seizure of a kukri and besides preparing the sketch map, a sketch map of the place of occurrence. Full stop. After completing investigation into the case, comma, Musalpur Police Station case number 41 of 2020, within bracket corresponding PRC case number 834 of 2020, comma, the IO submitted a charge sheet under section 173 to CRPC. Provide charge sheet number 41 of charge sheet number 20/2020 on 25/06/2020, finding a privacy case well established against the accused for committing the offenses under section 302 IPC and section 201, comma, IPC. Full stop. মাজত এটা সোমাই আহিব, the IO after going to the place of occurrence, comma, that is the house of the accused, took the accused into custody. Full stop. Para. On submission of the charge sheet, comma, the learned Chief Judicial Magistrate Baksa Musalpur secured the appearance of the accused from jail custody on 02/11/2020. Full stop. After query, comma, after making inquiry with the accused, comma, a legal aid counsel was appointed to represent the accused in the case. Full stop. as the offense under section 302 IPC is exclusively tribal by the Court of Sessions, the learned Chief Judicial Magistrate Baksa complied with the procedure prescribed in section 207 CRPC by furnishing copies of the case to the accused on 2/11/2020. Poster. Thereafter, the case records of PRC case number 834/2020. The learned Chief Judicial Magistrate by an order of commitment dated 2/11/2020 committed the case records of PRC case number so to the Court of Sessions, Baksa Mosalpur for trial by notifying the public prosecutor as regards commitment of the case and by directing the jail authority to cause production of the accused before the Court of Sessions on 11/11/2020. Post of para. On receipt of the case records of PRC case number 834/2020, the Court of Sessions, Baksa, Mosalpur, the trial court for short, registered the same as Sessions case number 50/2020, post of before the trial court, the case for the prosecution was opened by the learned public prosecutor, post of after hearing after appearance. On appearance of the accused before the learned trial court, the case of the prosecution was opened by the learned public prosecutor, post of after hearing the learned public prosecutor and the learned defense counsel, and perusal of the materials available in the case record, the learned trial court framed the following charge. Is brought on 23/12/2020 is put. When the charge any guilty report was not. Any idea or guilty plead করেছেন নাকি? Guilty plead করেছেন নাকি? File. What is it from? The charge was read over and explained to the accused. So the accused pleaded not guilty to the charge and claimed to be tried. So during the course of the trial, the prosecution in order to bring home the charge, examined 11 number of witnesses, including the IO and the autopsy doctor, namely page, page 77. And exhibited 7 number of documents, namely page 77. The prosecution also exhibited 2 material exhibits, and they were page 78. Full stop. 1 court witness, Soron Ramsiari, who the son of the accused and the deceased was examined as CW1. Full stop. After closure of the evidence from the prosecution side, the accused was examined under section 313, CRPC, and he was asked to explain. No, and sorry, he was offered to explain the incriminating evidence which have emerged from the prosecution evidence. First of, the plea of the accused was denial. First of, after when accused was asked as to whether he would adduce defense evidence, he declined to adduce any defense evidence. First of, after hearing the learned counsel for the parties and upon evaluation of the evidence took materials on record, the learned trial court holding the accused guilty of the offense under section 302, IPC, delivered the judgment and order dated so and so, impugned hearing. We have heard MS B. Chaudhary, learned amicus curiae for the accused appellant, and MS A. Begum, learned additional public prosecutor for the respondent state. Full stop. M.H. Chaudhary, learned amicus curiae, appearing for the accused appellant, has submitted that the learned trial court has erred in placing absolute reliance in the testimony of a child witness, who was examined as CW1. Full stop. it has been contended that the testimony of a child witness is to be considered with care and caution. Pusto. M.A. Chaudhuri has further contended that the learned trial court has placed reliance in extrajudicial confessions of few of the prosecution witnesses. To hold that the accused had confessed about the commission of crime of murder of his wife. Pusto, containing that an extrajudicial confession by itself is a weak piece of evidence requiring corroboration. By credible evidence, comma, M.H. Chaudhuri has also contended that the extrajudicial, the so-called, the purported extrajudicial confession was alleged to be made much after the death of the deceased. Full stop. The learned amicus curiae has also expressed doubt about the manner of recovery of the alleged weapon of assault. Full stop. It has been contended that the kukri, seized during the course of investigation cannot be held as the weapon of assault, as the same was not sent for serological examination. Full stop. The learned, it has been contended that the learned trial court had also had also failed to take into consideration the explanation given by the accused during his examination under section 313 CRPC, wherein he mentioned about involvement of other persons as the perpetrator of the crime. Full stop. Containing as above, comma, learned amicus curiae has submitted that the case of the prosecution is is full of infirmities, and it is settled principle of law that benefit of doubt, comma, at all stages, comma, goes in favor of the accused. In such view of the matter, comma, the judgment and order of conviction and sentence passed by the learned trial court is required to be set aside on the ground that the prosecution has failed to prove that its case beyond all reasonable doubts. Full stop. Para. Strenuously opposing the contentions of learned amicus curiae, MS Begum, learned additional public prosecutor appearing for the state, has submitted that in the prosecution, in the case in hand, the prosecution was successful in bringing all the, in proving all the required circumstances by cogent and credible evidence. Full stop. The explanation provided sought to be projected by the accused during his examination under Section 313 CRPC was clearly not true, and in view of such false explanation, in view of such disbelievable explanation, it emerges, the explanation emerges, such false explanation has emerged as an additional link corroborating the case of the prosecution. Full stop. The extrajudicial confession, the testimonies of the prosecution witnesses regarding extrajudicial confession were not at all disputed by the defense during the trial. And as such, the plea, the contention of the learned amicus curiae that such extrajudicial confession is not to be believed is not acceptable at all. Full stop. The learned additional public prosecutor has contended that the dead body of a deceased was recovered after recovered from inside the house of the accused, and the same is a clear pointer that the accused had the exclusive knowledge about the place where the deceased, where the dead body of the deceased was kept concealed. Full stop. The weapon of assault, that is the kukri, was handed over to police by the accused himself at the place of occurrence. And as by the time the kukri was handed over, a period of more than about 6 days had elapsed, none the fact of not sending the same for serological examination cannot be cannot have an effect in the case of the prosecution. Poster. The manner in which the extrajudicial confession was made by the accused and the testimony of the court witness, CW1, go to conclusively prove that it was the accused and none else, who was the perpetrator of the crime. Full stop. From the nature of injuries found on the person of the deceased, it is clear. It is conclusive that the death of the deceased was due to an act of murder. Full stop. By so canvassing, the learned additional public prosecutor has submitted that the learned trial court, has rightly returned the finding of guilt against the accused, the appeal is bereft of any merits deserving dismissal. Full stop. We have given our due consideration. We have given due consideration to the rival submissions of the learned counsel for the parties, and have also perused the evidence stroke materials on record, including the ocular evidence and the documentary evidence, by going through the case records of Sessions case number 50 stroke of 2020, in original. Full stop. As the learned counsel for the parties have made advanced arguments on the aspect of extrajudicial confession and the extrajudicial confession of the accused is also one of the basis on which the learned trial court has reached the finding of guilt, comma, it is apt, comma, at first, comma, to refer to the evidence stroke materials available, available, evidence stroke materials late. On that point, full stop. Para. The prosecution witness, comma, PW1 is the government Gaura and the informant as PW2 and the informant as PW1 is the president of the village, comma, number 2, Sandipur. Full stop. PW3, comma, Sonaram Goyari. PW3, not PW4. PW3. PW3. Oh, no. PW3 government Gaura. PW2 informant PW2. Huh? Police. PW, the prosecution witnesses, comma, PW4. PW5. PW6. PW7. PW8. PW9 and PW11 are all co-villagers, are all residents of village number 2, Santipur, and are co-villagers of the accused and the deceased. Posto. Para. In his posto, posto, in their testimonies, comma, PW 4 to PW 11 have all deposed that it was correct me if I am wrong, right? It was PW 3, Somnath Sharma, before whom the accused had confessed first, correct? Poster 3, poster. Para. In his testimony, PW 3, Somnath Sharma deposed to the effect that it was on a day, it was on a day, what do you mean day, on a day, in May 2020, the accused came to his house in the morning and disclosed to him within bracket PW3 that he, within bracket, the accused, had killed his wife, Fishi Musahari. Full stop. When such disclosure was made, PW3 took the accused with him to his village. Full stop. To his village, to the village of the accused. Full stop. Hey, I got a government to the PW3 Somnath, a resident of village Bhutan Khuti. Bhutan Khuti. Full stop. When they reached the village of the accused, the villagers gathered at a place, and before those villagers and in presence of PW3, the accused again confessed that he had killed his wife, Fishi Musahari. Ramsiari. Full stop. Thereafter, a village male was called wherein also the accused had confessed that he had killed his wife. Full stop. The matter was thereafter telephonically informed to police. Full stop. Police personnel came to the village of the accused after about half an hour after the village male. Full stop. An executive magistrate also accompanied the police personnel. Full stop. PW3 further stated that before the police personnel and the magistrate, the accused again confessed that he had killed his wife. Full stop. If magistrate is there, 26 bar is not there. If magistrate is available, bar under 26 will not be there. You say? So, I don't know. PW3 further stated that when police asked the accused about the dead body, the accused himself dug the earth under the Chang or English কি হবে? Chang, CHANG, Chang to কি হবে? Chang, bracket থৈ দিব কিবা এটা। Of his house and fetch the dead body of his wife from there, full stop. The accused disclosed that he had killed his wife by kukri, and thereafter, he produced the kukri to the police. Full stop. The kukri was thereafter seized by police by preparing a seizure list, EXT4, wherein and PW3 identifies his signature therein as EXT41. Poster. PW3 further stated that inquest on the dead body was held by the executive magistrate in his presence, and he exhibited the inquest report as EXT2, which is signature therein as EXT22. Full stop. The kukri seized by the seizure list, EXT4, when shown to him, PW3, identified the kukri, met EXT1 as the offending kukri, as the one which the accused produced before the police. Full stop. Sub-para. During cross-examination, PW3 deposed that police personnel came to the place of occurrence on receiving his telephonic information. The FIR was lodged subsequently, and after lodging of the FIR only, his statement was recorded by police. Full stop. This witness further stated that FIR was lodged after arrival of the police personnel at the place of occurrence. Full stop. PW3 denied a suggestion that he did not give any statement before police in connection with the case, and that he had deposed falsely. Full stop. From the above testimony of PW3, who is the government Gambura, it has emerged that he was the first person before whom the accused stated to have confessed that he had killed his wife, Fishi Musahari. Ramchiari. Full stop. It has further emerged that After such disclosure of the accused before PW3, both PW3 and the accused proceeded to the village of the accused, number 2, Santipur. Pusto. Reaching there, at village Santipur, a number of villagers gathered at a place, and before the gathering of such villagers, the accused confessed again that he had killed his wife, Fishi Ramsiari. Pusto. Pera. It is a case of the prosecution that no, na Taragoto. এটা উপরে। PW3 has also made mention of a village mall wherein the accused had again confessed that he had killed his wife. Para. It was after such confessions of the accused, the police was informed. Para. The PW, sorry, the informant, that's PW2, Amrit Brahmo, testified to the fact that the occurrence took place in the year 2020. PW2 stated that when the wife of the deceased accused, Fishi Ramsiari was not seen by the neighbors for a time, they made searches for her, but she could not be traced out. PW2 stated that after about 6 days, the accused visited the house of the government Gaumura, Somnath Sharma, within bracket PW3, and confessed that he confessed before him, within bracket PW3, that he, within bracket the accused, had killed his wife. Thereafter, the accused, accompanied by PW3, informed the villagers at a village mill, which was presided over by him. PW2 stated that at the village mill, the accused confessed before them that he had killed his wife and dug her under the soil inside his house. It was thereafter, the police was informed. Full stop. Then police personnel arrived at the village and took the accused into custody. Full stop. An executive magistrate also came with the police personnel. Full stop. At the house of the accused, the accused dug the earth of his house and took out the dead body of his wife in the presence of the executive magistrate and the police personnel. Apart from him, the government Gamura, PW3, and other villagers. Full stop. একটা word here, ডাকটু নয়, disinterred. Disinterred. DIS INTERRED. Exhumed to Salar. Stated that accused had confessed before them that he had killed his wife by stabbing her with a sharp kukuri, within brackets, sharp cutting weapon. And the accused himself produced the kukri to the police. Full stop. PW2 identified the kukri, shown to him in the court, as the one shown to him as Matt EXT1, as the one which the accused produced before the police. Full stop. PW2 further stated that he was a witness to the seizure of the kukuri, which the police had seized by a seizure list. Full stop. PW2 exhibited the FIR lodged by him as EXT1, with his signature therein as EXT11. Full stop. Like PW3, PW2 also stated that it was PW3 who telephonically informed the police prior to the institution of the FIR EXT1 by him in the capacity of the president of the village. So PW2 stated that his statement was recorded by police during the investigation. Full stop. Subpara. During cross-examination, PW2 stated that a kukri like Matt EXT1 is usually kept almost in every household of the village. Full stop. PW2 also stated that the wife of the accused used to visit others, houses of other persons, and the accused used to enter into quarrels with her. Full stop. PW2 further stated that he never saw the wife of the accused interacting with other male persons of their village. Full stop. When suggestions were given to PW3, he denied those suggestions. Full stop. PW3 denied suggestions that he, in his previous police statement, did not state that the accused dug the earth of his house and fetched the dead body of his wife, semicolon, and that, he did not state that police and executive magistrate came to the house of the accused. Full stop. Para. From the testimony of PW2, who is the president of the village, during, during, no, by giving testimony. The PW2, the president of the village, had corroborated the testimony of PW3 on the aspects that the accused first visited the house of PW3 and after confessing before PW3, both PW3 and the accused came to the village of the accused to inform the villagers. Full stop. There was a village mill which was presided over by PW2, and in the said village mill, the accused again confessed confessed before them that he had killed his wife and dug her under the soil inside his house. Full stop. Hmm? Buried her inside. Buried her. Dagbuli was buried her. Poster. It was this witness, like PW3, comma, had deposed that after the accused made confessions before PW3 at first and thereafter, comma, before the villagers during the village meal, comma, the executive magistrate and the police personnel came to the village and thereafter, comma, proceeded to the house of the accused. Full stop. Para. PW4, comma, Sonaram Goyari also testified that it was on 20/05/2020, comma, the accused made confession before the villagers that he had killed his wife. Full stop. Hearing about the incident, comma, PW4 stated to have visited the house of the accused and going there, comma, he found presence of the accused, comma, the Gaubura and other villagers there. PW4 stated that accused stated before them that he had killed his wife. Full stop. It was after such confession, comma, the Gaubura PW3 telephonically informed the police and the police personnel accompanied by the executive magistrate came to the house of the accused. Thereafter, full stop. Before PW4 further stated that before when police asked the accused, comma, the accused confessed again that he had killed his wife and buried her under the soil of his house. Full stop. Thereafter, comma, the accused himself dug out the earth and disinterred the dead body of his wife. Full stop. PW4 further stated that the accused himself produced and handed over the kukri to the police personnel, and the same was seized by police in his presence. PW4. By the seizure list, comma, EXT4, full stop. PW4 proved his signature in the seizure list EXT4 as EXT42, full stop. PW4 also identified the kukri, comma, when shown to him in the court, comma, as MATXT1, comma, as the one which the accused produced before the police. Post of Sapera. In cross-examination, comma, the defense put a number of suggestions before him, and PW4 denied all those suggestions categorically. Full stop. Para. The prosecution witnesses, comma, PW 5 comma PW 6 comma PW 7 PW 8 PW 9 and PW 10 have all corroborated the testimonies of PW 2, PW 3 and PW 4 on the points that, on the aspects that the accused had made confession before PW 3 at first and thereafter, comma, before them by disclosing that he had killed his wife and thereafter, comma, buried her dead body under the soil in the inside of his house. Full stop. These prosecution witnesses have also corroborated the testimony of PW 2, PW 3, and PW 4 on the point that the executive magistrate and the police personnel had arrived, had come to the village and went to the house of the accused, and thereafter, comma, went to the house of the accused after the confession of the accused regarding killing of his wife by him, and after PW 3 telephonically informed about the matter to the police at Nikasi outpost. Full stop. These prosecution witnesses had also corroborated PW 2, 3 and 4. On the point that after arrival of the executive magistrate and the police personnel, the accused, after confessing that he had killed his wife, dug out the soil of a place inside his house and disinterred the dead body of his wife therefrom. Full stop. These prosecution witnesses have also supplemented the testimonies of PW2, PW3, and PW4 on the point that it was the accused who, after confessing that he had killed his wife by kukri, handed over the kukri to the police and the kukri was seized by way of a seizure list, ext 4 in presence of PW2, PW3, PW4, seizure list খন ক'ত আছে? Seizure list খন page 90. Ninety. Eleven. Police now, yeah. Sana. Who subscribed their signature on witnessing the seizure. Full stop. The prosecution witnesses, PW2, PW3, PW4, had identified a kukri as, when shown to them as mat ext 1, as the one which the accused had handed over to police in their presence. Full stop. On scrutiny, comma, it is found that the prosecution, the aforementioned prosecution witnesses were not cross-examined by the defense on any of the aforementioned aspects. Okay. Post. Para. A reference to the medical evidence which are in the forms of the testimony of the autopsy doctor, comma, PW1 and the postmortem examination report, comma, EXT1 can be referred to find out about the nature of death met by the deceased. Post of subpara. PW1, comma, Dr. Manoj Majumdar was, comma, on 20/05/2020, comma, was serving as the senior medical and health officer at Dr. Robi Boro Civil Hospital, comma, Mosolpur. Full stop. PW1 testified to the effect that at 4:15 p.m. on 20/05/2020, comma, he performed postmortem examination on the dead body of Fishy Ramsiari, comma, a female aged about 48 years, comma, in connection with Musalpur Police Station case number 41/2020. Comma, after the dead body was identified by UBC, comma, Rahul Bormon and Sansuma Doimari, PW6. Full stop. PW1 stated that after conducting autopsy on the dead body, comma, he found the following. Page 9 star 2 star. PW1 testified that after autopsy, comma, He opined that the death was due to the injuries sustained and all the injuries were ante-mortem in nature. Full stop. It was his opinion that the death was caused by sharp cutting weapon and death had occurred. The approximate time of death was 3-7 days. Full stop. PW1 proved the post-mortem examination PMA report as EXT1 and identified his signature therein as EXT11 and the signature of Sri Subhas Chandra Sharma, Superintendent of Robi Boro, Dr. Robi Boro Civil Hospital as EXT12, respectively. Full stop. PW1 also exhibited the inquest report as EXT2 and his signature therein as EXT21 and the dead body chalan as EXT3 with his signature therein as EXT31. Full stop. Subpara. Notably, cross-examination of PW1 was declined by the defense. Full stop. PME to vote. PME to. Subpara. From the PME report EXT1 in the PME report, it was recorded that the arrival of the dead body was at 3:45 p.m. on 20/05/2020 and the postmortem examination was performed at 4:15 p.m. on 20/05/2020. Full stop. In the PMA report EXT1, the following findings were recorded. Page 82. Page 82, pencil. Remarks by civil servant. It's not a report to. Exhibit to control. Postmortem, exhibit postmortem. Prior to the postmortem examination, inquest proceeding was conducted and The findings of the inquest proceeding was recorded in the inquest report in an inquest report EXC2 by the conducting executive magistrate. Post of executive magistrate and circle officer, Baksa Revenue Circle. It was postmortem. Remarks from medical health officer. Let's say, clinical. After centers. এবার ইয়াৰ পৰা চাই ল'ব হা ইয়াৰ টেগ মাৰি দিবচোন ডাঙৰ টেগ এটা মাৰি এবাৰ কম্পেয়াৰ কৰি ল'ব in the inquest report EXT 2, it was recorded that the inquest was held at 1:20 p.m. at number 2 village Santipur on 20/05/2020. Post of the dead body was shown and identified by the accused. Post of cut marks on neck, waist, bottom, hand, thighs, etc. were recorded. Post of the inquest report কোনকেইটা inquest report কোনকেইটা কৰিছে witness PW 6 PW 6 আছে PW 6 আগুৱা পিছে ল'ব হা PW 6 Huh? PW6 testified that the inquest proceeding was done in his presence and he exhibited the inquest report as EXT2 and identified his signature therein as EXT2 within bracket 3. Oops. Need to exhume with lyrics. EX. Oh, no, E. The testimony of the IO. PW11. was to the effect that when on when he was in charge of Nikasi outpost under Musalpur police station, comma, he received an information telephonically at about 10 a.m. on 20/05/2020 from Omrit Brahma, PW2, no, he received telephonically, no. He received the FIR from Omrit Brahma. He has received telephonically, received information, no. He received the FIR. After recording the FIR in the general diary entry, comma, he forwarded the same to the officer in charge, Musalpur police station, for registering a case. Full stop. On being authorized by the officer in charge, Musalpur police station, comma, he, PW 11, after recording the statement of the informant, comma, started preliminary investigation. Full stop. After after intimating the details about the occurrence to the officer in charge, comma, superintendent of police and the district magistrate Baksa, comma, formal requisition was submitted to the district magistrate for deputing a magistrate for disinterring the dead body and to conduct the inquest. Full stop. Then, comma, he, accompanied by the officer in charge, Musalpur police station, and the circle officer, Musalpur, when proceeded to the place of occurrence, that is the house of the accused, in village number 2, Santipur. And after reaching the PO, comma, he interrogated the accused in presence of public. Post of PW 11 testified that the accused confessed before him that because of quarrel, comma, he, on the night of 14/5/2020, committed the murder of his wife, comma, Fishy Ramsheri, inside his house by slashing her with a kukuri. Full stop. It was further confessed before him that the dead body was buried under the earth inside the house by digging. Full stop. PW 11 further stated that the accused himself in presence of him and other police personnel, the executive magistrate and the villagers, including the Gaubura, disinterred the dead body of his wife. Full stop. The disinterred dead body was found partially decomposed. The entire so PW11 also stated that the entire proceeding was recorded. Also stated that audio video recording was made of the entire proceeding. Thereafter, the inquest was done by the circle officer Musalpur before forwarding the dead body to Musalpur Civil Hospital. PW11 admitted that stated that after digging out, after disinterring the dead body, the accused was taken into custody by him. Prior to that, the accused brought out the kukri from inside his house and handed over the kukri to him. Accordingly, he sees the same in presence of witnesses, provide seizure list, EXT4, and PW11 identifies his signature therein as EXT43. PW11 also identified the signature of the accused in EXT4 as EXT44. Full stop. PW11 also exhibited the FIR EXT1 and the sketch map of the PO EXT5, the kukri mat EXT1, the inquest report EXT2 serially queryable, search sheet EXT6, dead body Salan EXT3, and the signatures appearing, and identified the signatures appearing therein. PW11 admitted that he did not send the kukri seized by the EXT4 to the forensic science laboratory for serological tests. Subhead. During cross-examination, PW11 stated that it was the Gaura who, at first, telephonically informed about the occurrence to him, but he did not record the same information in the general diary entry. He further stated that he did not proceed to the place of occurrence after receiving such telephonic information. He did not proceed immediately after receiving. He proceeded to the house of the accused at around 10 a.m. And a case was registered in the police station at around 11:15 a.m. Worcester. PW 11 further stated that he recorded the statement of the son of the accused, Soron Narjari, who was about 9 years of age. Post of the IO, PW 11 was asked by defense, by referring to parts of the previous statements of PW 2 and PW 4 and PW 6. Purportedly to bring out contradiction that these witnesses did not made statements did not make such previous statements, as they had deposed before the court. Post. The proceedings, the audio video recordings of the proceedings, MET EXT 2 was put under objection by the defense side. Full stop. Where? On from the testimony of the IO, PW 11, it is found that the sequence of events, his testimony as regards the sequence of events, including the information given by the Gaura PW 3 telephonically at first, semicolon, the institution of the FIR by PW 2, semicolon, the confession made by the accused before the police personnel, executive magistrate, and the villagers after arrival of the team of police personnel and the executive magistrate at the place of occurrence, that is the house of the accused, semicolon. The disinterment of the dead body of the deceased by the accused from inside the house, from inside his house, semicolon, and handing over of the cookery by the accused to the police personnel, semicolon, are found in conformity with the testimonies of the other prosecution witnesses, comma, already discussed herein above. Full stop. The defense by way of cross-examination did not elicit anything on the material points to dent the case of the prosecution in any manner. Full stop. Para. It is uh, it is in in presence of the above at this juncture, comma, we turn to the testimony of the Soron Ramsiari, comma, the minor son of the accused and the deceased, comma, who testified as CW1. Full stop. At the time of giving testimony, comma, CW1 was aged about 10 years. Full stop. We found that in order to ascertain as to whether he was capable to testify, comma, the learned trial court asked a number of questions to him for answer, and on the basis of the answers given by CW1, in a language understood by him, comma, the learned trial court had found that CW1 was capable to depose as the as he had given answers rationally to the questions put to him. First. In his testimony, comma, CW1 11 will question 1 CW1 stated that his mother, comma, Pishi Ramshari, had expired and she was hacked by his father, comma, that is the accused. In an incident which took place inside their house in a night. Poster. Stating further, sorry, CW1 further stated that on the night of the occurrence, comma, he was woken up by his father from his sleep. Poster. His father then asked him to hold a torch. Poster. Thereafter, comma, his father flashed the torch and kept it on the bed. Poster. By flashing the torch and keeping it on the bed, comma, his father hacked his mother by a kukuri. Poster. CW1 further stated that prior to the hacking, comma, he was taken into lab by his mother. Poster. On being hacked, comma, his mother screamed. Poster. After hacking his mother, comma, his father dug a ditch inside the house and buried her there. Poster. When Sedodu was asked about the when CW1 was further asked, he replied that after the incident, he fell asleep. Full stop. In cross-examination, CW1 stated that after the incident, he was questioned by police and he could not understand Assamese, he could not say anything then. Full stop. CW1 stated that once his father was left the house for about 2-3 days. Full stop. As regards the incident, I'm sorry, stop. When CW was asked as to whether his parents quarreled with each other on the night of the occurrence, CW replied to the effect that he was sleeping at that point of time and he could not say as to whether any quarrel took place or not. Full stop. But they quarreled for a short while after he woke up on the night of the occurrence. Full stop. Paras. It is in the presence of the above evidence stroke materials on record, the respective contentions advanced by the parties are required to be considered. Full stop. Vera. As the contestation is on the matter of extrajudicial confession, the contestation as done like full stop. As the as the contestation, a reference to a reference to Section 24 of the Evidence Act comma 1872 is necessary. Full stop. It is laid down in section 24 that a confession made by an accused, লিখে দিব। It is true, it is true that the an extrajudicial confession is considered to be a weak piece of evidence. Right? Full stop. Bella. Therefore, comma, an extrajudicial confession must be accepted with great care and caution. Usually considered to be weak piece of, weak. If it is not supported by other evidence on record, comma, it fails to inspire confidence and it if it is not supported by other evidence on record. It shall not be treated as a strong piece of evidence for the purpose of arriving at the conclusion of guilt. Full stop. There is, comma, however, comma, no absolute rule that an extrajudicial confession can never be the basis of a conviction. Comma, although ordinarily an extrajudicial confession should be corroborated by some other material. Full stop. To act on an extrajudicial confession, comma, the court is to be satisfied that the confession was voluntary and was not as a result of inducement, comma, threat or promise as contemplated by section 24 of the Indian Evidence Act 1872. Furthermore, comma, the extent of acceptability of an extrajudicial confession depends on the trustworthiness of the witness before whom it is given and the circumstances in which it was given. Full stop. The prosecution has a duty to establish that the confession was made by the accused. The confession was made by the accused voluntarily. And the confession and there was truth. No, no, and the confession was made, and the confession which was made was true. Full stop. Reverting back to the facts of the case in hand. Jasmine, listen, লম্বা করে Jasmine আছে নাকি লম্বা? এই দত্ত, এটা যে পক্সো কেস আছে, পক্সো কনভিকশন যে আছে আপিল করেছিল, ওই যে লেবিয়া মেজর এবং ডিসকাস চাইল্ড উইটনেস আছে, ওটা বনাই থৈছিল, তারপর মোৰটোকে কপি কৰি দিবি, reverting like to the facts of the case in hand, comma. It is found, comma, as discussed here in above, comma, that the accused made the confession before the PW43, comma, the government Gaura of the village. Full stop. When PW3 testified as regards the confession made before him by the accused, comma, such testimony of PW3 was never challenged by the defense. Full stop. Never challenged in any manner whatsoever by the defense, comma, not to speak of about any inducement, comma, threat, or not to speak of from the standpoints of any inducement, comma, threat or promise. Full stop. It is further established from the testimonies of the other prosecution witnesses, comma, as discussed here in above, as mentioned here in above, comma, the accused had confessed before the villagers once again, comma, in presence of PW3, comma, yeah, I go once again to cut it, comma, once again, by confessing that he had killed his wife and by a kukuri, and after killing his wife, comma, he buried the dead body inside, at a place inside his house. Full stop. There is no evidence to the effect that the accused, prior to making such confession by him, comma, was threatened, was induced or threatened or promised in any manner by these villagers. Full stop. The government, Gaambura, comma, the village president or the villagers before whom the accused made the confession twice, comma, could be termed as persons in authority to give rise to a belief in the mind of the accused that by confessing before them, comma, he would gain any advantage or avoid any evil. Full stop. The facts, the facts, sorry, nothing has been brought on record by the defense during the course of the trial to infer that the confessions made by the accused on those two occasions were not voluntary in nature. Full stop. When The events disclosed by the accused, when the events stated to have been disclosed by the accused in his extrajudicial confessions are considered with the events unfolded during the subsequent period comma it appears that the extrajudicial confession, there was truth in the extrajudicial confessions. Full stop. The reason to deduce such a view is that the confession made by the accused that he had killed his wife by a kukri is consistent with the medical evidence comma as testified by the autopsy Dr. PW1 and as emerged from the PME report EXT1 that the injuries sustained by the deceased were caused by a sharp cutting weapon. As per the seizure list, comma EXT4, comma seizure was made of a Nepali kukuri, comma made of iron, having a wooden handle, comma of 11 inches in length. Full stop. A number of prosecution witnesses like I think PW2, PW3 and PW4 check had testified that the kukri, comma exhibited at MAD EXT1 seized by seizure list EXT4 was the one which was handed over to police by the accused on 20/5/2020. Full stop. The view that the confession had the element of truthfulness is further is fortified by the fact that as per the FIR EXT1, the murder was committed, the act of murder was committed on 14/5/2020. And the disclosure was made on 20/05/2020. And the autopsy doctor in his testimony, PW1 in his testimony, and the PMA report, EXT1, testified and reported that the death of the deceased had occurred approximate time of death was 3 to 7 days. Full stop. Time to answer. What do you think? Not sending the kukuri for serological examination cannot be held to be a circumstance to the benefit of the accused. Full stop. The alleged assault, the assault on the disease was made in or about on at a much earlier period, in and around 14/5/2020. And a kukri was handed over by the accused to the police only on 20/5/2020. Almost ruling out the possibility of finding any incriminatory evidence in the absence of any blood stains on it. Full stop. The spectrum of recovery from a place inside the house of the deceased had gone in conformity with the confession made by him before PW3 and others. Full stop. Out of schools. Hmm. I guess, uh, when the 13. 313. In the circumstance it was there. When the accused was provided the opportunity to explain the circumstances appearing in the evidence against him at the stage of 313, section 3, at the stage of his examination. At the stage of the examination under section 313, comma, the accused admitted that he confessed before PW2 that he had committed the murder. Full stop. At the same time, comma, he stated that he did not commit the murder. Full stop. PW32. As regards when he was asked to explain as to whether he had gone to the house of PW3 and made the confession, comma, as testified by PW3, comma, the accused admitted that he had gone to the house of PW3 and confessed before him that he had hacked his wife. Full stop.
When the villagers gathered.
When the accused was asked to explain as to whether PW3 and he came to the village and in presence of villagers too, comma, he had confessed that he had killed his wife, comma, the accused stating the same to be false, that a village male was called before the arrival of the police, comma, had admitted that when the villagers had gathered, comma, he admitted before them that he had killed his wife. Full stop.
What did you explain for
The accused also admitted that he disinterred, not dead body, or exhumed, he buried I think exhumed no, inside my house. Exhume the dead body. Yes, sir. The accused admitted about the digging out the dead body of his wife, about taking out the dead body of his wife by digging earth inside his house in presence of the villagers, the executive magistrate and the police. Full stop. While making denial of few of the other incriminating circumstances, the accused mentioned that named 3 persons as the assailants of his wife. Full stop. The accused also sought to provide, the accused also sought to project that members of a political party at the time of election in April last, the time of election held in April last, got his wife drunk and committed bad act on her and thereafter, killed her. Full stop. As it has, as is evident from the PME report, EXT1 and the testimony of the autopsy doctor PW1, the death of the deceased had occurred. The approximate time of death of the disease was 3 to 7 days from 25/2020. Full stop. If the date of the disease had occurred in presence of such evidence, the projection of the accused that his wife was killed by the members of a political party in April is not only to be disbelieved, but it emerges as a false explanation. Full stop. The other projection that the 3 persons, named by him, had killed his wife also appears to be an implausible one, is not a plausible one. For the reason that any husband, if his wife was killed by other assailants, comma, the husband should have been ought to have been the first person to bring the matter to the knowledge of the police. Full stop. Not bringing such act of murder of his wife by other assailants for a period of for a period of 3 to 7 days, comma, taking a CUE from the PME report, comma, is itself is not a normal human conduct. Full stop. এই এটা লাইন তোমার থাকিব এইটো এডিশনেলি তাৰ পিছত লিখক পেৰা এনেই লিখি ৰাখক এডিশনেল লিংক বুলি এটা ৰাখিব পেৰা it is settled that a child witness if found competent to depose on the facts and to be reliable one, comma, his evidence could be the basis of conviction. Full stop. Even in the absence of oath, comma, in more judgment of 23 to us, para 23 to us, purpose high logo. Even in the absence of oath, comma, the evidence of a child witness can be considered under section 111 of the Evidence Act, comma, subject to the rider that such child witness is able to understand the questions and able to give rational answers thereof. The evidence of a child witness and the credibility depends upon the facts and circumstances of each case. Full stop. In a state of Uttar Pradesh versus Krishna Master, comma, 2010 12 SCC 324, comma, the Honorable Supreme Court has held that there is no principle of law that it is inconceivable that a child of tender age would not be able to recapitulate the facts in his memory. Full stop. A child is always receptive to abnormal events which take place in his life and would never forget those events for the rest of his life. Full stop. A child may be able to recapitulate carefully and exactly when asked about the same in the future. Full stop. In case the child explains the relevant events of the crime without improvements or embellishments, and the same inspires the confidence of the court, comma, his deposition does not require any corroboration whatsoever. Full stop. A child at a tender age is incapable of having any malice or ill will against any person. Full stop. Therefore, there must be something on record to satisfy the court that something had gone wrong between the date of the incident and recording of the evidence of the child witness, due to which the child wanted to implicate the accused falsely in a case of serious nature. Full stop. Para. Itu sih, Krishna Masa itu. Oh. Ah. Ah. As regards, Para, as regards the acceptability of the testimony of a child witness, comma, in state of Madhya Pradesh versus Ramesh and Ananda, comma, on the test of acceptability of the testimony of a child witness, comma, the following have been observed, para 11, প্রশ্ন হয় জানো, and para 14. এটা তো করবে para 11 and para 14 মাজত study দিব. When para when by taking into consideration the above principles, as regards the testimony of a child witness, the testimony of CW C1 is examined, comma, we find that it was only after CW1 was found that he was able to understand the questions put to him and had provided rational answers, comma, and thereby, comma, and which satisfied the learned trial court as regards his suitability and competency to depose about the events. Good stuff. We find Pusto. When the when CW was examined thereafter by the prosecution and and cross-examined by the defense, comma, CW, he, who was aged about 10 years, comma, gave have answered, no, deposed in a manner wherefrom it does not emerge that he was being tutored in any manner or was influenced by any supervening event. Full stop. Para. When the ocular evidence and the medical evidence, comma, as mentioned here in above, comma, are led by the prosecution in the case are considered in its entirety, comma, we find that the extrajudicial confession, comma, made by the accused, comma, on 2 occasions were voluntary and true in nature, and it received overwhelming corroboration on all the material points from the other ocular evidence and the documentary evidence. Full stop. Notwithstanding the principle that the evidence of even a child witness is sufficient to base a conviction, comma, and the testimony of CW1 in the case in hand is also found credible and trustworthy, inspiring the confidence of the court. We find that the testimony of CW1 is corroborated by the by all, by the testimonies of the other prosecution witnesses and the documentary evidence. Full stop. Having considered, having evaluated, evaluated the evidence stroke materials on record in its entirety, comma, we do not find any fault. Huh? We do not find any infirmity in the judgment and order of the learned trial court. Infirmity in the finding reached by the learned trial court that the prosecution has been able to prove the case beyond all reasonable doubts. That it was the accused alone who was the perpetrator of the crime of uxoricide. Full stop. Finding no region, comma, much less good and sufficient region, comma, to interfere with the judgment and order of sentence and conviction passed by the learned trial court. We find that the instant criminal appeal is devoid of any merits and the same is deserved to be dismissed. Full stop. It is accordingly ordered. Full stop. Appreciation. Send back the case record. We having regard to the fact that the deceased had left behind two or left behind a minor child at the time of his death. We reiterate the observation and the direction made by the learned trial court as regards compensation to be made under section 357 A, comma, CRPC. Full stop. We further observe that if the inquiry ordered by the learned trial court has not been completed till date, comma, the such inquiry shall be completed with utmost expedition. Yes, Mr. Das? Yes. What happened to your compensation? Amount?